Good evening and welcome. Before we begin our program, I'd like to ask you to turn off your cell phones and to let you know that the restrooms are through the door at the back, and then turn right. You'll see a sign that says restrooms on the door, and you need to go downstairs. I'm Pat Yasha, a member of the Social Justice Committee of the First Unitarian Universalist Society of Exeter, usually referred to as FUSE. In this election year, we are particularly interested in a free and responsible search for truth and meaning, and the use of the democratic process within our society to that end. We are sponsoring this forum tonight about 3 proposed amendments to the Constitution of New Hampshire. We have left copies of those 3 proposed amendments on your chairs, and notice there's space if you want to take notes or write a question for use later in the evening. Our co-sponsors for this evening's forums are We the People and Granite State Priorities. We the People is dedicated to the public examination of issues where government and religion intersect, and is comprised of the Exeter Congregational Church, Christ Church Episcopal, and FUSE. Granite State Priorities focuses on New Hampshire's revenue system. To support our goal, we have given you each the handouts. I've already mentioned that. Here are our panel members for this evening. The Honorable Kenneth Weyler, Republican Representative from Kingston. Kathy Sullivan, former State Democratic Party Chair from Concord.
No, Manchester.
Manchester, sorry.
I love it.
And Steve Norton, Director of the New Hampshire Center of Public Policy Studies. To moderate the discussion and the question and answer period, I introduce to you now Charles Tucker, our Exeter Town Moderator.
The first thing we will do is have Steve Norton explain how New Hampshire amends its constitution, because some of you know that, but some of you don't, or used to and don't remember anymore. And it will put in context what's going to be on the ballot in November. So Steve.
Thank you. How many people here have read the New Hampshire Constitution? I had the good fortune of going to...
Speak into the mic, Steve.
I'm sorry, speak directly to the mic, yes. I had the good fortune of going to the St. Paul's Advanced Studies program. I grew up in Guilford, New Hampshire, and Judge Souter did a mock trial for us, and he said he would not do the mock trial unless we had all read the Constitution, so we all had to read it, and we skimmed it. And this season, we have seen kind of an amazing number of questions about the Constitution. We had an educational constitutional amendment that didn't actually make it. We had 3 that have. And I don't know, if there are constitutional scholars here, I don't know that we've had a period of constitutional concern like we've had in this past period. Any time?
84 is brought out as being a huge
time also. Times of great stress, times of great political unrest often bring these types of questions out. But anyway, I'm going to talk briefly about the process, and it was designed by the Founding Fathers to be quite burdensome and quite a hurdle, no matter how you get to the people. The legislature can put, by 2/3 vote, a question to the people, and that's how they've done it for 2 of the constitutional amendments. One being the question about the judicial role and the legislature's role, and who shall have the most power in that relationship. And then the second is this question about banning an income tax or tax on personal income. The third question about whether or not the people of New Hampshire should have a constitutional convention is a different process for getting questions to the people of New Hampshire. That simply requires a majority vote of the legislature to say to the people of New Hampshire, do you want to have a constitutional convention, and raise questions about the Constitution. What brings those 2 together is the process of ratification. No matter what, any change to the Constitution requires 2/3 of the citizens of New Hampshire to vote in favor of that change. So even though there are 2 different processes, They will both get to the people, and we're required to have 2/3 vote to get approval. I'm going to take a step away for a minute, but I'm going to ask a question, and that question is, when you think about constitutional amendments, the language is often hard to understand, and the full implications are never really terribly well articulated. And so when you are asking your representatives or the people about what it is that they're trying to accomplish, ask it in terms of goals. What are the goals of this particular constitutional amendment rather than the specifics? And I'll just give you an example. It strikes me as potentially problematic to change a constitution beyond saying that someone has the authority to tax, either prohibiting or allowing a specific type of tax. And that's because times change. In New Hampshire, we've had a couple of very significant changes in the way we tax. One was around the property tax a long time ago, when we went from taxing... Sorry, back there. One was when we went from taxing land that was in use by our farmers. That was how we thought about the property tax. And if we had said at that time, we're going to define property or tax or wealth in terms of this and this alone, it would not have allowed our concept of taxation to evolve as our communities evolved and our understanding of what wealth is evolved. We had a similar thing happen in the 1970s. Walter Peterson essentially eliminated something called the stock and trade tax and implemented what's currently known as the business profits tax and ultimately the business enterprise tax. A constitutional amendment which had defined wealth in a particular way and our ability to tax that wealth in a particular way would have made it impossible to put this system in place. Now, no one could have predicted that our understanding of wealth would change over that time period. So what I'm talking about is long periods of change. And what are the policy goals that we're trying to set out as a group of policymakers for our ability to tax? Not the specific taxes, but what are the long-term goals and how does that relate to these questions? So I'll step aside now and I'll let other folks.
Situations that need a law change. The legislature will hold public hearings to decide the necessity of the law change and will debate it in the two chambers, the Senate and the House. If it passes, then we send it to the governor for approval or veto. So that's the process that you have as citizens to protect yourself. You don't have much in the court. So please vote for this amendment. As I said, it is supported by the Supreme Court justices. I thank you for your attention.
Is that working? Okay. First of all, thank you all for coming. I'm really happy to see that there's so many people here who are taking an interest in these constitutional amendments, which are somewhat dry. Some folks would consider boring, but I actually look at them as being extremely interesting and also can have a real impact on how our state operates. I oppose this particular amendment basically because I'm a big fan of the separation of powers. We have 3 branches of government: executive, judiciary, legislative. And those 3 branches of government should be as independent of each other as the nature of the free government will provide. That's in our Constitution. There is no compelling reason in a free government for the legislative branch to have veto authority over the court's administrative and procedural rules. As former governor and Republican Steve Norton has said, this would amount to a legislative takeover of the judiciary, and it should be voted down. There is no other state in the country that has a provision like this in their constitution. This is an extreme proposal that would subject the courts to the whim of the legislature. And with all due respect to Representative Weyler, this legislature, and he would probably argue about the legislature that preceded him, sometimes whims can go against the will of the majority of the people. Because sometimes legislatures are elected without telling the people what they really stand for. I'll give you some example of rules. The courts establish rules on things as varied as the forms of writs and petitions and how discovery is conducted. There is a procedure in place for public input into judicial rules. These are sometimes complicated matters, sometimes simple. But these are rules that are set up by the people who are experts at it and are qualified to establish their own procedural rules. Now, there are members of the legislature who have been angry with the court since the Claremont decision. And ever since that decision, they have been unhappy with the court system in our state and have looked at ways to try to reel in what they see as an out-of-control court. I look at it as an independent judiciary. There are things that this legislature has done that I'm not a fan of, but I don't think that the court should have veto authority over what the legislative rules are. Each body should have the ability to manage their own affairs. And that's the system we have now. If this amendment passes, the legislature and the judiciary will no longer be co-equal. And I'm even more opposed to this now, having heard Representative Weyler's reasons for support. He talked about the Committee on Redress of Grievances. This is a committee that basically listens to one side from a disgruntled litigant. And without hearing talk about rules of evidence, any real evidence, without having the opportunity for cross-examination, makes decisions to recommend that judges be impeached because one person who's a disgruntled litigant may go before that committee, tell their tale, one-sided, and then that committee acts, and then they recommend that judges be impeached. That's not the way a free and independent judiciary should be treated. The legislature has its role, which is to enact statutes. The judiciary has its role, which is to interpret the law and to manage its own judicial administration, just as the legislature is entitled to manage its own legislative administration. And we have the executive branch to implement these things. Each branch has a function. We should not upset the carefully balanced system of three independent branches of government which have stood our democracy in good stead, not just in New Hampshire, but in our country as a whole, since our founding fathers adopted our constitutions. And that's why I hope and I ask that each one of you, carefully considering this amendment, will put the three independent branches of government first, the idea that we have these independent branches, and keep that in mind and vote this down. Thank you very much.
Well, I would have a question to both.
Okay, speak in the microphone, then to the public.
I would just ask a question both. There was a change to the Constitution in 1978, and it's hard to understand this conversation without understanding what that change was about. And so, to the extent that you could help the audience understand why that change was required, it will inform their thinking about this.
Okay.
I had a long conversation today with Bill Gardner, the Secretary of State. It goes back a long way. And the explanation he gave me is, I sit here between two lawyers who, among other titles, have officer of the court. Is it surprising that they are defending the court and wanting it to have more power than the legislature, including lawmaking power? His explanation to me was, in 72, the law, it was 74 was the vote, and that was a year that the primary was more for the Democrats, because I think it was Nixon was running for re-election. So most of the Republican voters didn't see any reason to come out. So a lot of the Democrat voters came out. and they voted in the Democrats, the lawyers that took over, they decided to make the court more powerful. Before that, the court was a creation of the legislature. It didn't have constitutional courts. The Supreme and Superior Court were not mentioned. It just said language something to whatever the legislature creates. The legislature was empowered to create all the functions of government. What departments they were, what the officers in those departments were, what the different departments were. We had a requirement to organize government. Yes, the three branches are separate, but they also have separate duties. As I have stated, they took over some of the lawmaking. That was inappropriate. What we're trying to do is restore that lawmaking ability back to the legislature where it belongs. So they took over that constitutional convention, and the one also in '84 was heavily dominated by lawyers. The one that you, Steve, talked about has been an activist one. I believe the numbers that Bill Gardner told me, there were 267 resolutions at that constitutional convention. 100 and something of them were passed and went on the ballot, but only 10 were ratified. So a lot of things came forward that changed the way we did business. In '84, we went from biennial sessions to annual sessions and have been there ever since. So yes, a lot of things happened that should not have happened. The lawyers are trying to take over our lives, excuse me, both of you, and that's where they showed their power. Thank you.
Control your life at all. I just wish you wouldn't want to control mine. That's for the ladies in the room. Let me go back further in history than Secretary of State Gardner. In the 1800s, and Representative Weyler was correct, the courts were not constitutional courts in the sense that they were not established by the constitutional form we have. So what would happen in the 1800s? Well, it wasn't the Republicans, the Whigs, get elected. All the judges were fired. And they appointed all the judges from their party. Then the Democrats got elected. And they threw out all the Whigs. Franklin Pierce was one of the big Democratic Party bosses, as a matter of fact, in any event. Then the Democrats got thrown out in Civil War. And the Republicans took over. And what happened? All the Democratic judges, well, not all of them, but most of them, out. And this happened, I think, 4 times during the 1800s. Now, in the 1900s, things got a little bit more civil amongst the politicians who conquered, and that did not happen. The courts were kept, statutes were not being amended to change the courts. And finally, the amendment was passed that we had constitutional courts. But that's the full background on this, is so that the courts are not a political football. I am not a litigator. I'm a real estate lawyer. I don't go to court. So I have no interest in whether the judges have more power or less power. I'll tell you, like other people, sometimes I sit, read the paper, and I say, gosh, I can't believe the courts did that. Some days I pick up the paper and I say, that's a good decision. And I think that's what we all do as citizens of this country. But there is a process to appoint judges. There is a process for rules to be adopted. And this entire process provides for some public input. And what it provides for, and what our current system does, is provides for 3 separate equal branches of government. I don't want the courts to control the legislature. I want the courts to do their job, which is to interpret and enforce the laws that are enacted by the legislature as the policy-making branch of government. By the same token, I don't want the legislature telling the courts what to do, because the courts are supposed to be the fair arbiter. They're the people we go to sit there fairly in judgment, based upon the arguments that are placed before them to make those judgments. The court should not be subject to the hammer of the legislature, because then we lose that ability. we lose some of that fairness and independence, which is so critically important to have in our judiciary. And so what I see here is an effort, and then you can see there's some real anger on the part of some of the legislature towards the court. And I'm hearing that from Representative Weyler, there's some real anger there. But that anger based on disagreement should not change our Constitution. We should never amend the Constitution in reaction to a temporary event, a temporary mood. We should look at our Constitution both in the context of the past and how we've reached this point, and what we're looking for in the future. And that's why we need to be so careful in amending our Constitution. And again, I would encourage you all to not vote for this amendment. Thank you.
Ken?
This was not done in anger. This has been going on for some years. Those are just some of the examples I spoke of. The least accountable people in state government are judges. There was a mechanism in place to replace judges who erred. We had a perfect example while I've been in the legislature of the Supreme Court justices sitting there and the judge there trying to have input into who would judge his divorce case. Now there's a real conflict. And most of the judges just said, well, you can't be in this discussion. But nobody really thought they should take any further action. And so very little was done. Somebody finally reported it to the Attorney General. He took some action, he brought it before the legislature, and we had to continue the action to impeach the judges who had allowed this to happen. Impeachment proceedings were brought. It was found, and Judge Brock was there for $2 million worth of law fees because he wouldn't give straight answers. He just kept evading and avoiding the question for hours and hours and hours. And of course, he wasn't under oath. And then he got trying to get us to pay his law bill for $2 million. He was impeached by the House, as was one other judge. But they went on to the Senate, and the Senate made rules to make it almost impossible to continue the impeachment. There was also a group called the Judicial Conduct Committee. They're supposed to keep the judges honest, and if someone has a real complaint about the judges, they can bring it before the Judicial Conduct Committee. I was reading today about the Professional Conduct Committee. That keeps the lawyers in line. And the Professional Conduct Committee talked about a lawyer today that they forbid to practice law for 3 years because he urged a couple to take an early settlement on her injuries so that he could immediately get $2 million and not have to wait and prolong the agony to collect the fee. So he had his ability to practice law removed for 3 years. That's not uncommon. What is less common is to ever see a judge disciplined by the Judicial Conduct Committee. I don't remember it happening. So judges are so protected that they can get away with almost anything. And then to have rules making that if we bring something to say, no, we created the district court, you can't have that type of thing. They will go to their own court and says, we say it's legal. What are you going to do? So that's why we'd like to bring some of the lawmaking back where it belongs, and that's what we need your help on this amendment. Thank you very much.
First of all, this amendment has nothing to do with the impeachment proceedings against Justice Brock. This would do nothing to address that situation. But I would say the system appeared to have worked. The system appeared to have worked because this did come out. The House did undertake impeachment proceedings. The decision made by the Senate was made by the Senate and had nothing to do with the rules promulgated by the court, which is the subject of this amendment. I do have to disagree that two things you said, which is this happens all the time. Thankfully, no, it doesn't. We don't have lawyers being disbarred all the time. We have a pretty good bar in the state of New Hampshire. I have to defend my sister and brother attorneys. Are there bad apples? Sure. Just like in any profession, just as I dare say in the legislature, sometimes people have to resign for doing things they shouldn't have done or making claims that they shouldn't make. That doesn't mean we should establish rules over the legislature with respect to their procedures. It's up to the legislature to take care of their own. And that's what happens in the legislature. If somebody undertakes an action that they should not undertake, it's the legislature. It is the legislature that is supposed to take care of that. Just as with the courts and the Judicial Conduct Committee. However, the legislature does have the power of impeachment, so if anything, the legislature does have more authority when it comes to judges who may act in a way that they should not act. And I also have to disagree with the comment about the Judicial Conduct Committee never doing anything about judges. I do remember one of our judges actually, I don't know if it was sent or maybe remember, for writing a letter that they said he shouldn't have written on some matter or on judicial letter. Another judge who was, I can't remember if it was a relative or someone involved in a DWI, and they said the judge acted in a way that was inappropriate, action was taken. The Judicial Conduct Committee does hear complaints, and they do act. So I have to disagree with that comment, Ms. Representative.
I'm not a constitutional expert, but it strikes me that the issue is less about lawmaking, more about legislative concerns about undisciplined power. And so my question is there a way, aside from amending the Constitution, that you could improve oversight of judges?
Yep.
One of the constitutional amendments that had come before us was to, and it's common in many states, is to have them renewed at some period of time, every 5 years or every 7 years. So if there was a judge that didn't reach the level of impeachment and you didn't want to spend millions of dollars impeaching that person or something like that, then they could come before a review board, they could look at the decisions, something as simple as, well, you've been overturned by the higher court the majority of times, or something like that. I guess you're not doing that good a job, you're not renewed. Something as simple as that. That unfortunately didn't achieve enough votes. But the judge that wrote the letter improperly is now the Chief Justice. So how much damage was done to her? Anyway, as I say, there's very little punishment ever meted out by the Judicial Conduct Committee.
The country, not New England, judges are elected, and they serve 2 years or 5 years, and then if they make enough unpopular decisions, they're down the drain. What about that?
Yes. I'm not morally opposed. I mean, as I said, there are some times when I read decisions and I tear my hair up. You have to worry about, will judges be not re-elected because of a temporary or particularly inflammatory event that may have happened. But I also have great trust in the voters too. So it seems to work in some states. I know that's what happens in New York. I have a friend who's an elected judge in upstate New York. And that's just the way it is. And people accept that as being very normal, and they like it. It seems to work. So that has never been something that's gained lots of approval in New Hampshire. Again, there's been talk about that in the legislature, but it hasn't happened. So I don't know. It seems to work in states that do it. In some states, I saw the event in Iowa where a number of judges were not re-elected on the Supreme Court after their decision on marriage equality. So I don't know. In California, sometimes you see judges who are not re-elected because of some particular decision. But then that's up to the voters. That's up to the voters to decide. So they could.
I'm a member of a national organization of state legislators, and one of the examples we heard some time ago, speaking of electing judges, a major law firm in Kansas put up one of their partners, and it was a big law firm, had a lot of money, they put a lot of money behind her, and she got elected as the Chief Justice. And she ended up, there was a court, if you go and remember the tobacco settlement and all the money that flowed from that. Billions of it went to lawyers. She gave the business to her old law firm, which collected the billions of dollars, and then subcontracted it out to someone else to do the busy work. So that shows you the problems that can be with elected people. So, whatever system you use can be influenced by money.
Somebody up here with a question, not a speech, but a question, Frank?
Yeah.
Real loud, because I'm going to pick up.
Okay, yeah. I heard Representative Weyler say all the Supreme Court justices are in favor of this, and my question is to Captain Sullivan. Is that your understanding?
I'm sorry, I didn't hear the first part.
Is it true that all the current Supreme Court justices are in favor of this amendment? How'd you know?
You know, as far as I know I saw something that Gary Hicks wrote something supporting it, but I gotta tell you, the Supreme Court's been under a lot of pressure from this legislature. Financially, they've been under, like, talk about the power of money. The legislature's got the power of the purse over the courts, which is a pretty hefty club to have over the courts. And I think there's actually been some use of that power with respect to the judiciary and their budget. And in any event, so right now I believe that is true, but as I said, sometimes the judges do things I don't agree with, and this is one of them. I think this is a mistake on the part of the judiciary. I think they felt that they had to have a compromise with the legislature, because the legislature, as I understand it, wanted to do something even more draconian, and the court said, we better compromise or else you may see an even worse amendment. And maybe Representative Weyler can tell me if that's correct or not.
Okay. There were several different versions and several different changes to this, but two of the prime drafters were in fact retired Supreme Court justices. So there's not much we can do to affect their retirement. It's a fixed thing, and it's said and done, and it's a system that's separate from the. It's new enough that it's not in the financial straits that the other state employee system is in. So money had no effect on those two people that helped draft this. And granted, there's always a compromise to be worked out. As I said, some of the earlier Chief Justices we had were people that wanted to assert themselves and didn't care what we said. They were going to run their own show. The present Chief Justice and the Chief Justices in the other superior and district courts have a different approach, that we're all working together to improve the government of New Hampshire. I appreciate working with those folks, and they realize that we need to work together for the people of New Hampshire. We're not out to be at odds with each other. Government works best that works together. So if you vote this amendment in, you are doing what the majority of us in government are wishing for, so that we can work together in your interest. And I thank you very much.
Mr. Upton, you want to say something? Gentlemen, you want to say something? There's a microphone over there. There's a microphone over there if you want to speak to it.
Use yours if I may.
Well, you may if you don't stay too long. Lawyers can go on, you know.
Pull it down. Yeah.
My name is Fred Upton. I'm a lawyer. I'm one of those people of whom Mr. Weyler is so very fond. I've been practicing law in this state for more than 60 years. My father, Robert Upton, was president of the Constitutional Convention in 1948, and my brother Dick was president of 2 Constitutional Conventions in 1964 and in 1978. There was a 1978 Constitutional Convention that passed the language that Mr. Weyler finds so offensive. CACR, Constitutional Amendment Concurrent Resolution 26, that's the one we're discussing, is a
blatant usurpation by the legislature of part of the judicial function. I think you've all heard of separation of powers. It's a fundamental doctrine that goes way back to our Bill of Rights in the original Constitution. Let me read it. It's beautiful language. I'm damn near blind, but I think I can read it. Separation of powers. In the government of this state, there are three essential. I'm going to need your help. Would you please read that for me?
In the government of this state, three essential powers thereof, to wit, the legislature, executive, and judicial, ought to be kept as separate from and independent of each other, as the nature of a free government will admit, or as is consistent with that chain of connection that binds the whole fabric of the Constitution in one indissoluble bond of union and amity. June 2nd, 1784.
That principle, separation of powers, came largely from James Madison. When you read the Federalist Papers, he talks about it. If one of the departments, the legislature, begins to usurp the powers of the judiciary, or the governor, or the executive, we start down the road of tyranny. But worse than that, when the legislature starts making rules for the court, rules for the administration of the courts, we get bad law. What in the world do legislatures know about rules of evidence? That's what we're talking about. Do you want the legislature to be making rules of evidence? I don't think so. This is anti-judge and nothing else. The legislature has had a war with the court ever since the Claremont decisions. I, for one, happen to think that the Claremont decisions, which held that the state of New Hampshire, as distinguished from subdivisions, has the prime obligation to provide every child with an adequate education. The legislature has been at war with that decision ever since it came down around the year 2000. And they never fully funded it. And this, I think, you can tell from Mr. Weyler's tone that they don't like judges. This is anti-judge. That's a terrible business. I want to just quote, if I can, again. I'll have trouble reading. The early judge, Jeremiah Parsons, who collaborated with Daniel Webster in the Dartmouth College case before the United States Supreme Court. He was a very learned gentleman. And this is what he had to say. This is in the New Hampshire reports. I can give you the page if you need it. If there is anything established by our Constitution, it is that the legislative department of our government should abstain from the exercise of judicial power as every way totally incompetent to the task. It is not, he refers to just one section that prohibits it. The whole Constitution prohibits it. I hope you'll give this, when you go to the poll, a decent burial.
If someone would like to speak to the contrary of that, I'll have them come up. Otherwise, we'll give Ken a minute if he wants to say anything, then we'll go to the next question. So if someone would like to speak to the contrary.
Yeah, not the contrary, but I just think for purpose of clarity, I think it would be good if we could.
How about you say who you are?
If we could add.
Who are you?
I'm sorry, my name is Bob Goodman. I live here in Exeter.
Okay.
And I guess what I'm getting at is this deals with a part of the courts that has to do with only the administration of the courts. The gentleman mentioned that got into rules of evidence. You know, does it go that far that the legislature can say what how the courts rule? I thought it just dealt with the administration.
It says the practice and procedure, so that and that the legislature shall have a concurrent power to regulate the same matters by statute. Now, I look at the rules of evidence and some of these other rules as being part of the procedural rules. It's civil procedure. This is what we think of as civil procedure and how cases are prosecuted, how cases are argued, how cases are heard before courts.
So you're saying it does?
Yes, yeah. And frankly, I expect this legislature, as currently constituted, would push the envelope as far as it could.
Ma'am?
Yes, this question is from Weyler and Lawyer. It has here that the House Code 242/96. I'd like to know how many Republicans versus Democrats voted for this.
I don't have that breakdown. I'm sure it's published, but I didn't look it up. I didn't think there'd be a question about that.
Okay, let's go on to Sullivan.
How do the justices get their jobs? And Mr. Weyler thinks that a lot of them are irresponsible. I wonder if he would propose a different way of getting more responsible people to be justices.
Okay, the first question is, how do you get to be a judge or Supreme Court Justice in New Hampshire? Procedurally, not politically.
Please don't misinterpret my remarks to say a lot of judges are irresponsible. I never said that statement. What I said is there is not enough accountability for the few who might be. I did not say that professional conduct for lawyers was happening all the time. I said it was not an infrequent occurrence. So please don't misinterpret my statements as it has been done here today. But let me say again about the usurpation that has been brought up. We firmly believe that by adding a statement that says, rules so promulgated shall have the effect of law, is a usurpation of the power that was read earlier about the legislature, which makes the laws. So we're trying to get away from that usurpation. And we have the cooperation of the courts, because finally we have people who are listening to us when we say, why are you trying to make laws when the Constitution clearly says that that's the legislature's job? And we have made laws about evidence, and they're on the books.
To answer your question with respect to how judges are appointed, under the administrations of Governor Shaheen and Governor Lynch, both of them had a committee that took in applications from people who are interested in becoming judges. They would review them, then make recommendations to the governors, and the governors would look at the recommendations and typically would choose from a little pool of nominees or that the committee suggested. And the committee was made up, I believe, of both lawyers and some lay folks. That's not a requirement, however. Under the administration of Governor Benson, he did away with the nomination committee process from the lawyers and lay people who had done that for Senator Shaheen, and then later on it was reintroduced with Governor Lynch. Governor Benson, as did prior governors, nominated who he thought should be a judge without going through that type of a process. And so it really is up to the governor to determine. Now, having said that, there is a check on the governor's authority because the Executive Council has to approve the governor's nomination. So it is not just the governor in and of himself who has the power he has the power to nominate, but the Executive Council has the authority and the jurisdiction to approve. And they hold hearings typically. They will have a public hearing at which people can come and give input with respect to the nomination, to the person nominated to be a judge. So that is the process. So depending upon the governor, there may or may not be a judicial selection committee to help the governor do that.
All right, let's go on to the next.
Can I do a follow-up, please, to Mr. Weyler's comment?
We're here till midnight. We're supposed to stop. We're supposed to stop discussion on this and do something else. And when we're all done, people want to listen some more. We'll come back to it. The second article we discussed is: are you in favor of amending the second part of the Constitution by inserting after Article 5-B a new article to read as follows: Article 5-C, income tax prohibited. Notwithstanding any general or special provisions of this Constitution, the General Court shall not have the power or authority to impose and levy any assessment, rate, or tax upon income earned by any natural person. However, nothing in this article shall be construed to prohibit any tax in effect January 1st, 2012, or assessment to the rate of such a tax. Mr. Weyler. I'll give you that. Somebody pull them over.
Thank you, Charlie. An income tax is the siren call that lures a government to the rocks of destruction. New Hampshire has a revenue mix that has allowed us to project accurately the revenue 27 months in advance. States that relied on an income tax, such as Colorado, saw their revenue shrink by 19% from 2000 to 2001. We could not balance a budget with that sort of volatility. It is important that you understand why this constitutional amendment needs your support. A supermajority of each legislative chamber voted in favor, knowing what problems an income tax would bring. Predictable revenue is so important with a two-year budget. In most states that have adopted an income tax recently, the public was convinced that an income tax would lower the property tax. Let me show you why the reality is different. Suppose we say that we'll dedicate $1 billion from income tax revenue to reduce property taxes. In New Hampshire, 33% of our property tax base is business property. This portion already pays business taxes, BET and BPT. They will not participate in an income tax. Another 17% are second homes. So those owners will pay the tax somewhere else, maybe another state. So that's 50% of the base, which sees a property tax reduction without participating in an income tax. The residential homeowner will pay the whole $1 billion while seeing half of that as a property tax reduction. This will result in a doubling of their tax burden for the average homeowner. Further complicating this scenario, are the 88,601, this was 2011 figures from Massachusetts, 88,601 New Hampshire residents who work in Massachusetts and pay $256 million in Massachusetts income tax. Smaller numbers also commute to Maine and Vermont. So we have something approaching 20% of our workforce who, again, will not participate in any New Hampshire income tax, unless it is higher than those other states, in which case they'll pay first at the state where they receive the pay, and then if we have something higher than those 5% or whatever they are, they'll pay that in addition to us. This brings another reduction to our base. Our experience in 1999, when we increased $200 million in education aid sent to municipalities, is very instructive. Some of us voted for it because we hoped it would reduce the property taxes. For many of the towns, they received this money after they had approved their school budgets. So 60% of the towns, it did reduce the property taxes, only for that year. The very next year, the education budget increased to use up everything else, and has continued on since, so that in the last 10 years, we've had a 95% increase in the education budgets while seeing a decrease in student enrollment. The cost of collecting an income tax is not insignificant. Our Department of Revenue Administration handles about 200,000 tax forms presently, and it costs $15 million to handle those tax forms. There are 663,922 federal income tax filers in our state. Some of those are joint returns. Now, if most of them end up filing a state return, the cost might be $45 to $50 million, even with a fairly simple form. If it's a complex form, it could be a lot more, and who knows what the form will be. And then if we look at the experience of states like New Jersey and Connecticut, which were some of the ones within the last 20 or 30 years that said, oh, if we could only pass an income tax, we could reduce the property taxes. So, New Jersey and Connecticut are number 1 and number 2 of the 50 states in having the highest property taxes. And they're still number 7 and number 2 in income taxes. In the 1990s, 3 million people moved from the 49 states that had an income tax to the 9 that did not. The figures are not yet available for the last 5 years census. Do not give up the New Hampshire advantage. Let these people who are tired of paying state income taxes come and enrich our state. If we pass this amendment, it'll be national news. People will be able to plan their future for years to come without suddenly being stuck with an income tax. It is vital that you support this amendment. In summary, income tax is too variable to be relied upon for a 2-year budget. It will not be as broad-based as one might think, due to all our citizens who work out of state and pay income taxes in those other states. It will not reduce the property tax as two different governments will be setting those rates. One is the state and the other the municipality. The history of other states that have passed this tax recently have all seen an increase in the overall tax burden for all their citizens, not just the wealthy. Putting this in our Constitution will put us in the forefront of states that want to protect their citizens' freedom and will give New Hampshire an even bigger advantage. Thank you.
You just heard Representative Weyler give an eloquent argument as to why New Hampshire should not have an income tax, and I agree with them 100%. I am opposed to an income tax, but I'm also opposed to this amendment. Actually, one of the major reasons I'm opposed to income taxes is I have worries about working people having their wages taxed. Our Constitution also requires that there be a flat level tax, so that it would have to be the same rate tax. We can't have graduated rate tax. But I am opposed to income tax. So I'm not going to argue about the merits of the tax system. We've been hearing that argument for 50 years, and we don't have an income tax. So why the sudden need for a constitutional amendment? I believe, and I think most people believe, that the Constitution should be a statement of principles and a broad overview of our governmental structure. Specific policies should be adopted by the legislature through the legislative process. And despite my recently found fear of the New Hampshire legislature, I still think it should be up to the legislature to pass laws on policy, and this is a policy issue. There is no compelling need for a constitutional amendment, and if there is no compelling need for one, we should not mess with our Constitution. This year, for example, both candidates for governor have pledged to veto a broad-based sales and income tax. But most importantly, this is how we feel here today in 2012. Why do we want to tie the hands of future generations? If this amendment passes, it would take a 2/3 majority to undo it. So maybe in the future, 2030, 2040, 2050, not going. Maybe 60% of the people in the state are going to want a different tax structure. Maybe times will have changed. But the voters of 2012 will have given the minority at that time the ability to stop what the majority, in fact a supermajority of 60, 61, 62% may want. I don't think that we, standing here today, should be telling our children, our grandchildren, what policies are good for them. I don't think we should govern from the grave. I think they should have the ability to make up their own minds. And with due respect to Representative Weyler, with whom I agree on the income tax, in 30 years, we may be in the minority. 20 years, I don't know. But I should not be telling people in the future what policies they should enact. They should be able to make their own policies based on what is happening at that time. In addition to that, I don't think the Constitution should be a political football. And let's be seriously clear about why this amendment, after 50 years of debate, and I remember my mother saying, when I was a kid, and she was in the legislature, that goddamn income tax just won't go away. And she was a good Democrat from Manchester. So anyway, so this has been on for 50 years. Why the need 2012? Oh, presidential election year? Let's get out the vote, drive the vote. That's what this is really about. This is a real great get out the vote opportunity, or so some Republicans think, by driving people to the polls to get them to vote against an income tax. Republicans think those folks are going to vote Republican. If we start treating our Constitution like a political tool, where do we stop? Because while the legislature is overwhelmingly Republican now, we all know 2 years ago it wasn't, and another 2 years it may not be. So then what will we Democrats do? Are we then going to start passing amendments to put on the ballot to drive the vote? That's no way to treat our Constitution. That's not serious government, and we should be serious about government. We should be serious about our Constitution. We should not use it as a political football, and I am really offended by this amendment. The first one scares me, because I think it's an intrusion on our 3 equal branches of government. This one offends me because it's using our Constitution for political purposes, and I think that's wrong. And last but not least, and this is also important, you never know. What if there's some unforeseen catastrophe, some unforeseen emergency? This amendment forces us to raise property taxes or business taxes, or actually to enact a sales tax. And someone at something I was at recently said, this really does, mean that in those circumstances, the state's forced probably into a sales tax situation. And what does that do to our state? So I oppose an income tax, but I also oppose this amendment, and I strongly encourage you to vote against it as well. Thank you.
Facts about tax structure, the way we spend, like this strikes me as a question of ideology, not fact. There's no public policy drive for an income tax at this point in time, and there's no evidence that this legislature or any other legislature would stop or would allow an income tax to go forward. So I think this conversation is less about the facts and more about the cultural components of our beliefs in ourselves. So I'm glad to answer facts, but that's probably where I'll stop.
So a friend called me today who can't be here because he's sick, and he said, could you ask if you live in New Hampshire and work in Massachusetts, you pay the Massachusetts income tax. If you live in Massachusetts and you work in New Hampshire, you pay the Massachusetts income tax. So the 88,000 people who live in New Hampshire and work out of state, how many people out of it live in Massachusetts and work here? And we would collect their income tax.
25,000.
Okay. There's a fact.
Yes.
Anything, questions or comments from out here? People would like to ask. I thought this would be the hot issue. Mr. Jones.
I would ask Mr. Weyler if he and the other people who voted for this amendment, from Dan Jones from Exeter, truly believe that future legislatures will be incompetent and unable to understand the arguments against an income tax, and that therefore they must be handcuffed.
Yes, you can.
One of the key items that got me to co-sponsor this was a book that's written every year by Richard Laffer. You remember him as an advisor to Ronald Reagan. He writes a book called Rich States, Poor States, and he updates it every year. In it, he highlights the 9 states without an income tax and how much better they are in almost every economic situation than the other 41. How much more growth there is, how much higher the average incomes are, and so on. And he also points out, I think it's the 2 states that are neighboring states, not neighboring, but perhaps it's Oklahoma and Tennessee. One had an income tax, the other did not. One is entertaining removing their income tax and bringing in a sales tax because they're looking at the other state that they find similar to them and saying, look how much better they've been in the last 10 years than we are. So a lot of us plan long term. Many businesses plan long term. More and more businesses, like information technology businesses, have high-paid workers. Those workers sometimes have a choice within the corporation of where shall we move. That has been said by some of the ones that have moved to our state. They're looking to plan long term. If we have something in the Constitution that says long term you can plan on not seeing an income tax in New Hampshire, then I think it will bring businesses to New Hampshire with high-priced jobs that we would not otherwise see. I would love to be the research capital of the country or something like that, which would happen if you're trying to recruit high-priced help, PhD scientists and engineers, and you're trying to say, we need to solve problems. Look at the quality of life in New Hampshire. Look at the fact you won't pay part of your income in an income tax to the state. Let's move to New Hampshire and open our business up. That's my target. That's why I think you need something that people can look at long term. It's not a political football in my mind. It's a long-term plan. I've spent a lot of time in the legislature. I've worked on a lot of long-term things, and that's why I'm in favor of this, and that's why I'm a co-sponsor.
Kathy, was anything with you? No. Steve?
You know, I let people have a chance to ask their questions.
Moving behind you, sir, and then...
Yes. My name is Ilse Andrews. I'm a voter in Exeter and an alumna with 2 degrees from UNH. Am I allowed a comment rather than a question?
If it's about the topic in front of us, yes.
It is,
okay.
Yes. I think if the current legislature were not so busy cutting back the endowment to UNH, you would have a perfect platform for making this a very highly desirable base for technology firms, because UNH has absolutely incredible programs to enhance modern technologies in the state.
Thank you. Mr. Morris.
Yeah, it's a minor point, but isn't it a little bit disingenuous in the analysis of states that have no income tax to count high income, because people go to those states because there's no income tax, so obviously they're going to have a much higher income.
I'll say that in fact your information is accurate, that there is a correlation between higher income and tax rate, and that should make sense to everybody. People are economic beings and they act, but they act for lots of different reasons. And I think one problem with this conversation is that it's not broad enough. That we're having a conversation about an income tax, and it's phrased as something about the New Hampshire Advantage, and I think the New Hampshire Advantage is much more complex.
Would you speak in the mic, please?
Yes, ma'am. Yes. That the New Hampshire Advantage is more complex, and that changes in tax policy are absolutely important. We rank 20th in the country with respect to our corporate taxation by a relatively conservative foundation. That tells you that we're not actually that good in our tax policy for corporations. But we also rank 46 in transportation. We rank #1 in quality of life. These are other factors which you need to consider. And to hang our hat in a conversation about the future of New Hampshire on tax structure, I think misses the point. It's absolutely important. This can be one part of a broad conversation, but I think our advantage, particularly in these times when our tailwind, lots of in-migration from Massachusetts and wealth into this state, is slowing and stopping and turning into a headwind, we need to be more subtle, I think, in our conversations about the New Hampshire Advantage.
Thanks. My name is Mark Clapton. I live in Exeter, lived here for 25 years, paid property taxes in New Hampshire for 20 years. Just a couple of things to note, and just perhaps to confirm these too, because you gentlemen and you, Mrs. Sullivan, know a lot more about this than I do. To say that tax on income is antithetical to New Hampshire is somewhat inaccurate. Does not the business enterprise tax payroll. So that's a payroll tax that certainly rests acquisitive power away from workers. It's only tax to the employer, but that's money that doesn't get to the employer. Second, as someone who's followed the legislature for years, I harken back to Walter Peterson and think what a very different kind of leader he was in his party than the current party, the current incarnation of the Republican Party. I don't want to be too political. But what I think of is since that time when I came of age, the restraint of both parties when they were in power and had decisive majorities, that restraint, I think was, for me, looking back as a kid educated in New Hampshire, really part of the New Hampshire Advantage. And I'm troubled by that lack of restraint that is manifested, I think, in this particular constitutional amendment. I think restraint and respect for minority opinions seems to have become in kind of short supply. And I think this is an example of it when you consider the source of a legislature that would allow, that has with equal vigor attempted to allow people to carry loaded weapons in places like courtrooms and in universities. So it's hard to separate all that and not see that, to see that this is somehow characterized by less restraint. I think it's lacking in restraint. And I just think that the point that we need to respect the fact that 20 years from now, 50 years from now, situations may change greatly. And I think it is overreaching at best and arrogant at worst to presume to know what our future needs would be. We need only look at some of the statutory laws regarding race and interracial marriage in the 1800s that have become so contrary to our nature as a nation. I just think we're running afoul of that idea of stability. I trust the legislature in 2020, 30, and 40, when my kids are my age, to make good decisions without tying their hands and taking it off the table. I think true conservatives will vote against this constitutional amendment because true conservatives, I think, are not for actions that radically take off the table options available to future populations. Thanks.
Live here in Exeter. However, I'm also one of those people that commutes to a job in Massachusetts. I work in the aerospace industry where we are experiencing 20 to 25% growth annually. And the main reason our company does not want to move to New Hampshire because we have to move is because of the instability they see at the legislative level. They don't want to walk into some place and then find out everything they've just moved and reinvested is now changed. Thank you.
Thank you. Yes, sir. Question first. Well, the most question.
Hi, my name's Nelson. I'm a recent resident to Exeter, 2 months. I moved from California 1 year ago to New Hampshire, and one of the main reasons is exactly this, the no state income tax. I work for a technology firm in Portsmouth, and passing an amendment like this just reassures young professionals that there is a future here in New Hampshire, and I hope more people go and decide along this.
I'll just say that I lived in New Hampshire 41 years and 2 months ago, and there was no state income tax. And I said, well, this situation will probably last for 3 to 4 years. And it's lasted for 40 years and 2 months so far. That's an observation.
We have the microphone here for a reason. If we could run it the way you run the deliberative session, people who want to ask questions stand in line and use the microphone, I think it would be better.
Okay, if they want to do it, it's fine. Yes, sir, in pink stripes.
Asking Sullivan a question. Primarily, you talk about legislating from the grave and the difficulty in which you see that imposing upon future generations. Then I have a question, what exactly is the Constitution? If it's not a tool of government that sets a framework for the government, and if you have such disdain for legislating from the grave, why heed the Constitution at all? And why do you have so much reverence for the Constitution if this is something that's an imposition?
Part of your question first. Why do I have so much respect for our Constitution? Because I have profound admiration, respect, and awe for that group of people who, not at 2 levels, in the United States Constitution and here in New Hampshire, who put together a framework of government that has lasted for over 200 years. That we do not change government here at the point of a gun. That we do it with the ballot box. That we have profound disagreements. And as you can tell, we have profound disagreements over many issues. Yet in November, we will walk to the ballot box and we will vote. And I hope that we change a lot of our legislature, and Representative Weyler hopes that we keep the majority of the Syrian legislature today. And that is the beauty of our Constitution. I love our Constitution. I love our freedoms. I love our liberties. My parents were both World War II veterans, both children of immigrants who came to this country because, in Ireland, people had no jobs, they had no education. Their parents, victims of a famine, came here because they could do so much and have so much opportunity. That's why I have so much respect for our Constitution. I think that's why we all do. And that's one of the reasons I'm so opposed to this amendment, because it should be, in my opinion, a Constitution is a broad statement of principles, those governing principles about freedom, about liberty, about the lack of government interference in my life and in your life, which is why I bet you're here tonight, because you don't want government interfering with your life. I don't want them interfering in my life either. I am a small government person. I also believe that policy should be left up to our legislature. We have a representative government, and we should trust our legislature. Sometimes they'll disappoint us, and I've been profoundly disappointed at times in this legislature, but I think we should trust them with policy, and this is a policy decision. So I believe our Constitution should be a broad statement of principles and a broad framework of government, but it should be left up to the legislature that's elected by the people every 2 years to fill in the blanks, to set the policy, to set the tax policy, set the revenue structure, decide where the money's going. That should be done every 2 years by the people who are elected by us to do that.
I'd like to speak on that a little bit because you use the terms freedom and liberty, and you're really using them, I think, very incorrectly. The nature of government, if you look throughout the course of history, is to oppress and oppose people and to do things that may end up being in opposition to the people that are being ruled. Now, the question here is about an income tax, and should this be part of our Constitution or not, but it really runs deeper than that. What we're talking about is handing over more power to government or keeping power and wealth at the level of the people so that there's a prevention of the government taking that wealth. Now, we have to ask ourselves, what is this wealth being used for? At this point in time, it may be used for something good. There might be some good idea, but we must be very cautious of when we hand over power to government, because at some point, somebody might use it for something evil. Now, my background, I run for state representative in Exeter because I believe that anything peaceful and voluntary is good. Now, government, you brought up the point, we're being forced to do this amendment at gunpoint. Well, that's how government does things. Government does things through force. Yes, you did. Now, I'd like to give a little example because I always give an anecdote, and she brought up World War II, and the world wars are a westernized example of when governments get out of hand. But about the year 1400, in the Middle East, there was a guy that came to power named Timur. And what this fellow did was he conquered vast regions of the Middle East, and he killed 17 million people. Now, in the time of the sword, that's quite a feat to kill 17 million people. The regional government in Tehran asked Timur, why did you do this? Or, you know, why did you get away with this? And his response was, the people let me. So don't let the government take power and wealth from you. It's your power and your wealth. The individual is the one who can govern themselves. Be very careful when you feed people that say, we want to take this wealth, we want to take this power, and use it for good. It can fall apart very quickly. That's why Representative Weyler is here supporting that we prevent government from expanding itself and taking wealth from people.
Thank you. Thank you.
I just have to say, I don't recall ever saying anything about this being passed at gunpoint, but maybe I missed something.
Sir, people want to know who you are. What's your name? You can say it for me.
Sir, I'm Chris Brock. I'm running for state rep in Exeter, and I believe the government should be limited.
Chris Dubrock.
The individual is the person that should have control of their own destiny.
So what party, are you running a party or libertarian, or what's your party affiliation, please?
I'm a Republican.
Thank you.
Anyway, and one other thing in answer to what you said, I guess I just have a lot more faith in the American system and the American people.
All right, let's go on to the third question, which is shall we call a constitutional convention? And Steve, you want to explain what happens and how people get elected to it and all that stuff?
No, the truth of that is I don't know how people are elected to that. I know the process by which it's called and that there are delegates that are created, but the specific rules about the delegation, I imagine Mr. Upton might be able to do a better job than I, given this family and this relationship.
Well, I think that.
But the policy question that's being raised is really, do we need to refresh our understanding of the Constitution and how it relates to what we do?
And I think the answer is, if we vote to have a constitutional convention by a simple majority, then next 2 years from now, there will be a chance of people to run for the convention, and they'll be elected 2 years from now to the convention, and then the convention will take place sometime in the ensuing several months, and then that convention in turn may or may not propose amendments to the Constitution which would get voted on 2 years later, if I understand the sequence of events, by the public at large. So it's a very long process.
The last the convention that resulted in the change to the judiciary powers took almost 8 years. Is that right? 7 years from beginning to end. So yeah, you're right. Long time.
And I think it's just like the...
Microphone.
I believe, I might be corrected on this, it's the same number as we have in the legislature, in same districts, but non-partisan.
Weren't you, Dan Jones, were you not council convention once? No?
No, I wasn't. I was a legislator. I was not.
Okay.
I went there.
All right. So, Ken, do you want to say why we should do this?
Thank you. Our Constitution is the bedrock and foundation of our government. Some call it sacred, which is a little much. Sacred implies it should remain the same forever. That was never the intent of our founders. In fact, they required that we should vote on having a constitutional convention every 7 years, which was later amended to every 10. And if the legislature did not put it on the ballot, the Secretary of State was required to do so. This is the case now. It's the Secretary of State that's putting it on the ballot. Our Constitution has been amended over 200 times in 17 different conventions. If it had not been amended, we would still be allowing only males to vote and only Protestants to hold office. Changes in technology and demographics are the chief drivers for change. So every year that ends in 2, we'll have to vote for a convention. That convention will be held 2 years later. So 2014, if this measure passes. Will there be proposals to amend? I think it's very likely. In the last two-year sessions, there were 33 constitutional amendment concurrent resolutions. We've discussed the 2 survivors. In the 1974 convention, there were 168 resolutions. 27 passed and went to the ballot in different years. There were just too many to put up. Most people wouldn't read that long ballot. 10 of those passed to become part of the Constitution. The 1984 convention was the last convention held. What complicated that was the change from biennial to annual sessions. That made it difficult for the legislature to clean out their offices and move out so that the conventioneers could take over the State House. This ballot measure was defeated, the Constitutional Convention that is. In 1992, 210,000 to 217,000. In 2002, it was defeated, 177,000 to 184,000. Not a big difference either of those years. The big difference in the numbers was one was the presidential election year. It only takes a majority to pass a convention call, but it takes 3/5 of the members present to move a resolution to the ballot, where there it requires 2/3 of the voters to ratify it to become part of the Constitution. There, of course, is an alternative way to amend the Constitution, which is by 3/5 of both the Senate and the House agreeing to the language to be placed on the ballot for voters to again decide. The approval is also the same, 2/3 of the voters to ratify. As a result of that court amendment passed in 1978 that we discussed earlier, the exact language that goes in the Constitution must be put on the ballot, not one that someone changes later. So there's not as much to say about this issue as there is the 2 earlier issues that we discussed. I didn't even realize that this was going to be controversial. I leave it up to you. There is a way to change the Constitution, whether it is by a convention or whether it is by the legislature. You can come to whoever's elected as your legislators and say, I'd like to amend the Constitution, and they can file that as a constitutional amendment concurrent resolution. Or you can try to become one of the members of the convention. What worked in the past was when we were on annual sessions, the legislature is only up there for 1 year. So if we voted in a constitutional convention, the second year, the convention occupied the same space and same offices. And of course, with all these resolutions, they broke it up into different groups to look it over. The legislature decides, again, Steve, the legislature decides the process, the time, and how those people are elected. So that's why it takes 2 years. If you decide in 2012 that you want a constitutional convention. In 2013, you will vote for those that will be in the convention, and in 2014, they will sit and decide on the resolutions that they adopt. I thought it was a good idea because it was something that we'd never done before, but many of my colleagues say, we got all these constitutional amendments, concurrent resolutions we look at every year anyway, so unless the public feels a strong need to have another process, I'm ambivalent on whether to support this or just say it's up to you. So I say it's up to you.
Just a couple of things. One is that the way the question reads, if a majority of the qualified voters approve this question, the delegates are chosen either at the next regular general election or at such earlier time as the legislature may provide, in the same manner and proportion as the representatives to the general court are chosen. So I think you may not have had the process quite right. It is possible that we could, if this passes, that we could elect Constitutional Convention delegates in 2013. That would mean a special election, so I would hope that the legislature, if this passes, wouldn't do that, but would instead wait until 2014. Otherwise, the taxpayers will bear the expense of a Constitutional Convention special election, statewide election, which I think is very costly, and I don't know why we would do that. I don't know why the legislature would want to schedule this in 2013. And again, if it passes, then it is in the same manner and proportion as the representatives to the general court are chosen. So there's not as much discretion as may have been indicated with respect to how this is done. And then they do convene at such time as the legislature directs, and then they recess from time to time and make such rules for the conduct of the convention as they may determine. Oops, they have rulemaking authority. And then again, they could put things on the ballot, amendments on the ballot by 3/5 vote. So, I'm actually not in favor of this at this time. We have had a number of proposed constitutional amendments bubbling and percolating after the legislative process. We used to have these constitutional conventions on a more regular basis, but that was before the Constitution was amended to allow the legislature to go through the legislative amendment process. So at this point, I just don't think it's necessary. And I have concerns too about the expense of the convention at this point in time. We've been having so many issues with respect to the budget and cutbacks and cutting money for education, cutting money for the university system, cutting money for this, cutting money for that. Do we really want to go to the expense of perhaps having a special election for the constitutional delegates? Do we want to go to the expense of paying for a constitutional convention? I'm guessing that people will be paid their mileage. Just the cost of having, in essence, almost a legislature in an extra session is costly. And so I just think financially it's more than what the taxpayer should have to pay for at this time. I'm also a little concerned that at this point, what type of constitutional convention do we end up with? Who runs, who gets elected, what particular special interests, what particular groups may try to influence the election of people to a constitutional convention. That worries me. If the election is held for delegates at the same time as the regular general election, now you've got, conceivably, you got 800 people running for the legislature. You've got, you don't know how many people running for 400 slots in the constitutional convention. Gets a little complicated. Now, I have great respect for a lot of the work that was done at constitutional conventions previously, and that's the one thing that gives me pause and makes me a little more ambivalent about this vote. But at the end of the day, I am going to vote against it for the reasons that I have given. I just think that financially it's a burden, and I don't think there's a need for it because of the legislative process of constitutional amendments. And I also think that just if we elect our delegates in 2014, if this passes, it's just going to be a really complicated election. And that's all I have to say on that one. Thank you.
This event promised the panel that they could leave at 8:45, so they have 5 more minutes. By this clock, which is not necessarily accurate. Anybody who hasn't said anything before we get back to Herb, that wants to say something or ask something, and if not, Herb had his hand up. Mr. Moyer, what would you like to ask or say?
Yeah,
you're the one who
I can speak loudly. Representative Weyler, in listening to your arguments on CACR 26, one of the main ones seemed to be that you thought the court decisions had the effect of law.
No.
No?
I thought that by adding a language, such rules shall have the force and effect of,
right.
Such rules so promulgated shall have the force and effect of law.
Yeah.
They were in effect making law, perhaps in contradiction to existing law or law that the legislature thought they could pass. And some are even fearful that since the legislature is called the general court, that they may even think they could make laws for the general court. Now, I never thought that was a possibility, but I read that comment from one of my colleagues. So they were usurping the lawmaking ability by putting that in there, because they should not be making laws. They make decisions, and they make rules for the functioning and administering of the court. They decide who will be the Chief Justice, who will be the clerk, who will be so on and so forth. We're not trying to interfere with that. We're just trying to say that you should not be making laws. You can make rules and procedures, that's all.
Excuse me, I have to correct you. The governor nominates the Chief Justice, not the justices.
Okay. My point is, my point is that if that's one of the main constructive arguments you have for putting forth the language of CACR 26, why didn't you just focus on that aspect and undo that language, and then that would solve your problems with the existing power of the court language?
Herb, it's been tried twice before, unsuccessfully, because of, as I said earlier, publicity by the judges and the lawyers, and they put a totally different spin on what we were attempting to do. I would love to have removed that language. The compromise with the participation of the Supreme Court justices was to add that additional sentence. That was acceptable to all of us because they were going to support it. What we wanted, the language that you point out that I would love to have eliminated, and that voted in the past to do so, did not successfully pass.
Thank you. And with that?
I thought there was one more question back there. I was changing his mind. Thank you, everybody. I hope you will go to the polls, vote with better educated knowledge of these particularly complicated issues. Spread the word to your friends. Give them the handouts in case they haven't heard about the amendments. And thank you to our panelists and to our moderator. Thank you very much.
Interpretation of what I said. It is online at a website. I'll let you get that, Herb. www.nhousehouse.com/2012 ballot issues/2012 ballot issues. Got it? So those are the comments I wrote and read. Not what somebody else said I said. Thank you.